Hello, everybody. Welcome back. This is Professor Zaid, and I'm recording this lecture to talk about intellectual property. This is part of my class, Data Science 650, but I'm posting this on YouTube for my students and for everybody else that would like to watch this lecture. So this is going to be a short lecture talking about intellectual property, and we're going to talk about different things. We're going to define what is intellectual property. We're going to talk about the different kinds of intellectual property, and we're going to give some examples about that and data protections and things like that. So how to protect your intellectual property rights. So let's start by defining intellectual property. And there are multiple definitions of it. Oxford English Dictionary defines IP, or intellectual property, as intangible property that is a result of creativity. If you look up also the definition on Wikipedia, it says something like category of property that includes intangible creations of the human intellect. There are many types of that. So also there are other definitions, like, for example, you could say that it's created, it's information created and owned, by a company. So if you talk about intellectual property information, for example, IP information is typically about products or services that make or perform. So IP is an obvious target for companies, competitors. So if you have one business is trying to protect its data, its information about intellectual property, it might be some competitors trying to get hold on that information. So so now we defined intellectual property. I'll give you a couple of definitions, one from Oxford Dictionary, English Dictionary, one from Wikipedia, and then my own definition as well. But there's also, we need to talk about the rights, intellectual property rights. What does that mean? When we talk about IP rights or intellectual property rights, we're talking about rights that adhere to such creations. So the creation that the company or the business creates, and grants that holder of that information or that rights the monopoly on the use of that creation for a specified period and subject to certain exceptions. And I give you a source there about that. Now, the laws, when we talk about intellectual property laws, each country has its own different sets of laws when it comes to intellectual property laws. Stanford University Libraries defines intellectual property laws as a wide body of federal and state laws in the United States. This is referring to United States laws that protects creative property, such as writings, music, drawings, paintings, photography, and films. So collectively, the body of law is called intellectual property law, which includes copyright, trademark, patent laws, and so on. So each applicable in various situations, and each with its own set of technical rules. So when obtaining permission to use creative works, you are concerned primarily with the copyright law. So now there are 4 types of intellectual property, and those 4 types are copyrights, patents, trademarks, trade secrets. And we're going to be talking about each one of them separately here. So talk about copyrights. Copyrights, basically, what is copyright? So when we talk about copyrights, it's a form of protection which is provided by the laws of the United States. So we mainly talk about these things. We talk about it from the perspective of the United States. And it's basically the same definition everywhere, but when we talk about laws, there are different laws. For example, Europe and United States might be a little bit different. So the copyright is the form of protection provided by the laws of the United States and Title 17 U.S. Code to the authors of the original works of authorship. So copyrights protect writings, music, pictures, music, art, and other forms of intellectual works. So the federal copyright law protects original creative works. Again, as I mentioned, that a work must meet certain minimum requirements to qualify for copyright protection, and the length of the protection also varies depending on when the work was created or when it was first published. We talk about one of the laws here, the Copyrights Act of 1976. And that act forms the basis of copyright law in the United States today. And it took effect, so this is dated 1976, but it took effect on January 1st, 1978, implementing fundamental and sweeping changes in many aspects of copyright laws. Copyright law. Copyright protection extends to all original works of authorship to take into account new kinds of media. So let's move on to the next one, trademarks. And trademarks basically is brand names like such Nike and Apple, as well as logos, slogans, and other devices that identify and distinguish products and services, are protected under federal and state trademark laws. Unlike copyrighted works, trademarks receive different degrees of protection, this depending on the different variables, including the consumer awareness of the trademark, the type of service and product it identifies, and the geographical area in which the trademark is used. So again, so the trademark is a word, phrase, symbol, or design, or combination of these, and identifies and distinguishes the source of the goods of one party from those of others. For example, like a company name, a logo on your company tagline can be trademarked. The trademark serves as a brand identifier for the business or the product. Types of trademarks, there are many types. The main ones here that we're going to discuss: generic mark, there's one called descriptive mark, suggestive mark, a fanciful mark or arbitrary mark, and then service mark. Generic marks are marks that use common everyday terms that everybody has the right to use. Like a generic mark will describe a particular class or a variety of which the good or service is a member. Like for example, attempting to use the term car for an automobile would be generic. You know, to allow someone to trademark a car, the word car would unfairly prevent everybody else from using that term in the sale of automobiles. So descriptive marks is the next one that we talk about. And the generic mark may represent a product or its provider. Descriptive mark applies solely to the merchandise. But since these words are considered part of the universal language, they are still non-registrable, right? Like adding a signifier to describe a significant quality of the product could qualify it for a trademark protection. And arbitrary or fanciful marks are made up words or real words that have no relationship to the good or service supplied, respectively. So these are the strongest types of marks and are afforded all protection. So so basically, because they are often made up or arbitrary words, it is less likely that anybody else is using them to describe the particular good or service. For example, Apple as it released to the computer products or relates to computer products, is an arbitrary mark, and they are therefore very strong because apples have nothing to do with computers. If Apple was used to describe an Apple product, it would be generic or descriptive, and this would be very weak. So the type of mark you select has a big impact on the amount of protection that is afforded to you. So it's very important for you to choose a strong word. Next one is a special the service marks, which is a special type of trademark, designates protection for non-product items such as services. Service mark differentiates an organization's class of services from other similar providers. An example here includes American Airlines, Hilton Hotels, and so on. Now, let's talk about there's actually one trade secrets. This slide here, I'll talk about trade secrets, which is the fourth type of intellectual property. And trade secrets, what are trade secrets? State and federal trade secret laws protect sensitive business information. An example of a trade secret would be a confidential marketing plan, for the introduction of a new software product or the secret recipe of a brand of salsa or a drink. So the extent of trade secret protection depends on whether the information gives the business an advantage over competitors, is kept a secret, and is not known by competitors. So any piece of confidential corporate information, again, which gives any business competitive advantage, can be considered trade secret. So just keep that in mind. Trade secret must be designated as such before it is leaked. So you have to specify that. One cannot simply say, I have a secret. You have to use the non-disclosure agreement and designate information as a trade secret in the contracts when dealing with partner companies and employees. So there are other ways to designate information as trade secret. You can read more about it. So now the right of publicity, the patchwork of state laws known as the right of publicity, which basically protects the image of and the name of the person. These laws protect against unauthorized use of a person's name or image for commercial purposes. For example, the use of your picture on a box of cereal. The extent of this protection varies from state to state. So if you want to know about your own state, you gotta do more of that. We talked about trade secrets, right of privacy, although not part of the intellectual property laws, but state privacy laws preserve the right of all people to be left alone. Invasion privacy occurs when someone publishes or publicly exploits information about another person's private affairs. So invasion of privacy laws prevent you from intruding on, exposing private facts about, or falsely portraying someone. So the extent of this protection may vary if the subject is public figure, for example, a celebrity or politician. The next one is patents, which is a type of limited duration protection that can be used to protect the inventions or discoveries, for example. So that are new, non-obvious, and useful, such as new process, machine, article, or of manufacture, or composition of matter. So a patent for an invention is the grant of a property right to the inventor. And this generally, when we talk about United States, for example, this patent lasts for about 20 years, generally, from when the inventor attempts to patent the invention by filing with the US government. You have to file with the US government. The list of things that can be patented is fairly lengthy and open to interpretations, but it covers anyone who invents or discovers any new or useful process, machine, manufacture, or composition of matter, or any new useful improvement thereof. So for a business or an inventor, this means that if you found a new way to make something or discovered the product you would like to take to the market, you would want to first patent the idea, so no one can take this idea and claim it to be their own. So we talked about before, talk about big data and social media and things like that. This is one of the things that you need to be concerned about. If your data is saved in the cloud, for example, how are you going to protect those ideas? So you may need to make sure those are secret information. So this is basically what patents are. And we talked about trade secrets. Now, who owns the data? Devices generate a significant volume of data and information, which is exactly the point. The more information generated, the better, more varied, and commercially insightful and predictive analysis. So now the question we ask now is, what can I do with this data, right? The data that you gather, that you collect. There are limitations on what individual organization can do with the data. There are privacy rules and regulations. Previously, we discussed GDPR, Global Data Protection Regulation, and we talked about, or General Data Protection Regulation, and we talked about other laws, talked about that, talks about privacy rules. How does big data causes intellectual property problems? There are examples here, like for example, web scraping. which is downloading a competitor's database from the web and it infringes on the competitor's rights. Using social networks API to get data on users. Data do not belong to you. You need to get a permission when doing this, and using tools to extract data without permissions. There are many other examples, like for example, like I said, data leakage and stuff like that. People save the data on the cloud, and their data gets data breaches and so on. This happens, and what if you have an idea? So you have to keep that in mind. So we talked about, we discussed intellectual property. We described the types of intellectual property. We talked about giving examples of each one of them. And so hopefully this will beneficial. There's a lot more to read about these topics. And there are articles that I have posted on my Blackboard for my class. So you can read those articles as well. And again, this is Professor Zaid. You can subscribe to my YouTube channel if you'd like to know more. And I regularly started to post videos there. And if you'd like to watch my future videos, you can subscribe to my channel. And again, thank you, and I'll see you next time.